Good afternoon, everyone. My name is Joshua Hibaveski, and thank you very much for coming along tonight to tonight's seminar about medical negligence. I understand that some of you in the past few months and years have received a cosmetic surgery that you may believe is negligent in nature. You might not be up to your standards, or you believe that the doctor breached part of his responsibility to you in the performance of that surgery. For you, I'm going to break down some of the key areas of negligence so you understand what is actually required to successfully prove it in a court of law. This should help some of you decide whether your circumstances warrant taking action and may just influence you in how you choose to interact with cosmetic surgeons in the future. As some of you may be aware, there is a difference between cosmetic and plastic surgeons. Anyone with a medical degree can actually call themselves a cosmetic surgeon. So be wary of people reading that title, as they might not have a large amount of qualifications. But plastic surgeons, on the other hand, are Commonwealth certified professionals. And this means they have a minimum of 12 years of training. So be careful who you choose to undergo operations with. If you are going to be suing somebody for the tort of negligence, there are three key things that you must prove in a court of law. Firstly, it must be demonstrated that you had a duty of care owed to you. The tort of negligence is a civil law remedy for situations in which a person has breached their duty to care for another person, which is why first you must prove that you were owed a duty of care. There are recognised relationships that warrant a duty of care. This type of relationship exists between everyone from lawyers to their clients, from teachers to their students, and doctor to patient relationship, which is of course most relevant to our talk tonight. It is well established in law that a qualified medical professional owes a duty of care to patients that they are treating. Secondly, there has to have been a breach to this duty that they owe you because of the special relationship. Within the world of cosmetic surgery, there are many ways in which this duty of care can be breached. Your surgery may have been performed in a negligible way. There may have been a lack of patient aftercare in respect to some of the serious side effects and complications that may arise from surgery. Or maybe your surgeon just forgot to inform you of some simple details, and this can be quite important because there is a notion of informed consent. After proving that there was a duty of care owed to you and that this duty of care was breached, you need to demonstrate causation. This means that you must prove that the actions of your doctor through the breach directly caused you loss or harm. There are multiple ways in which a surgeon can be seen as having caused a breach of their duty of care. A doctor may be found to have correctly performed a surgery, however, they failed to warn their patient of the possible side effects or the exact procedure that was going to be taking place. It is on the onus of the defendant to demonstrate causation that a failure to warn was connected to the plaintiff's harm. There's a direct correlation between these two that you have to prove that the doctor owed you a duty of care. The case of Chappell v. Hart is significant in the field of medical negligence. It explored the circumstances of causation in relation to a doctor's duty to warn patients of possible complications. For the plaintiff to show causation, they must prove that had they been sufficiently warned, they would have acted in a way to avoid the risk. The negligent action that increases the chance of harm and the occurrence of injury gives rise to sufficient causation. It is the duty of the plaintiff to demonstrate on the balance of probabilities an issue of causation. Through exploring the details of causation in a court of law, the severity of a doctor's breach can be considered and the appropriate damages would be calculated. Hopefully this gives you an idea of how negligence claims are processed in court, if any of you are interested in taking them up. The general test for demonstrating this causation can be found in the Civil Liabilities Act of 2003. This is part of the legislation created by the Australian government to create uniform law across Australia, where previously there may not have been. It also enshrines into law some of the complicated elements of common law that can be complex to understand. Known to lawyers as the Bolam Principle, a doctor acting in line with common opinion of those working within that field, they cannot be found to have acted negligently. This principle has been adapted into law under Section 22 of the Civil Liabilities Act. It defines professionals as not breaching a duty if during that professional service they act in a way that was widely accepted by their peer professional group. In cases where a doctor has failed to warn their patient of a possible risk or complication, the implementation of the Bolam test has been limited, however. Practices universally practiced by specific groups of practitioners may still be found to be negligent. This is because patients have a right to be informed of that procedure as affirmed in Australia under Section 21 of the Common Law Act. Is because patients have a right to be informed of their procedures as affirmed in Australia under Section 21 of the Civil Liabilities Act, and very importantly in common law through the case of Rogers v. Whitaker. This case affirmed that a doctor has a duty to warn a patient of a material risk inherent in the proposed treatment that they may undergo. Even in situations where the predominant medical practice may to not be informed patients of a remote risk, courts may still find that doctors had a legal obligation to do so. The court's ability to disagree with commonly accepted practice provides well-needed oversight for the conduct of these medical professionals. In a world of cosmetic surgery that is sometimes and in some ways unregulated, as was just alluded to, little is being done to develop national standards for the accreditation of cosmetic surgery providers. The main recognised training bodies within Australia is the Australian Society of Plastic Surgeons and the Australian College of Cosmetic Surgery. Despite the proliferation of cosmetic surgeries, there's no legal barriers to prevent any qualified medical practitioner from performing operations. Patients will only be able to seek damages if it is proven that a doctor's negligence caused the damage. The case of Chappell v. Hart is significant in this field of medical negligence. It explores the circumstances of causation in relation to a doctor's duty to warn patients of possible complications. For the plaintiff to demonstrate causation, they must show that they had been sufficiently warned they would have acted to avoid the risk. The negligent action that increases the chance of harm and the occurrence of that injury gives rise to sufficient causation. Further cases such as Tabbitt v. Gett have significantly altered how causation is considered within negligence cases. It ruled against a plaintiff's ability to recover losses based on the possibility that they lost their chance of receiving a better patient outcome. This would mean, for people here tonight, that you cannot sue a cosmetic surgeon if you have lost the ability to have the surgery performed by another doctor. You can't sue for the loss of chance. Many developments in the field of cosmetic surgery are actually originating in New South Wales. This is because it is a cosmetic centre where there are particular centrings of wealth and people interested in having these procedures. So, people having more procedures, there will naturally be more cases where things can go wrong, so more cases make it to the courts, and there is more need for law and regulation. Law that originates in New South Wales has a tendency to make its way to the rest of Australia. There were significant regulations introduced in 2016 to ensure patient safety was maximised, and then in 2018 the government commissioned a review of the entire industry. These developments have led to legislation that cosmetic and plastic surgery must take place on a licensed medical premises. So please come up afterwards and let me know if this hasn't happened. And it also saw tighter regulation on the drugs used to conduct the surgeries, meaning that these are occurring with greater oversight. The report by the New South Wales government also placed a great importance on ensuring that patients make their own inquiries and ensure that their choices are truly informed. This relates strongly to the issue of informed consent. Doctors have a proactive and a reactive duty to answer questions that are posed to them by patients. This means that they must inform the patient of any complications that may arise from the surgery or possible repercussions. And also, if they are asked any questions, they have to give honest answers about the possible outcomes of the surgery or other facts. The current system for allowing patients to make negligence claim against their doctors is mostly friendly towards people who have claims. There just has to be a pretty strict criteria for which they can prove, as I stated at the start of this. It's difficult to determine any possible reforms that could be brought into this tort of negligence. Most of the requirements come from the legislature in terms of making things more safer for patients and ensuring stricter regulation of people practicing as cosmetic surgeons. Patients tend to have greater outcomes when they are informed of the industry and can make better decisions for what they are more comfortable with. Doing your research about the surgeon who you are choosing and where it is going to be conducted will always yield a better patient result. A couple of comments from notable people in the world of plastic and cosmetic surgery. The president of the Australian Plastic Surgeons Society, Rob Sheen, notes that there is no nationally accredited and easily recognisable system for patients to know whether or not they are in safe hands. Patient outcomes and trust in the system could, however, be improved through a legislative requirement for surgeons to inform their patients of their qualifications and experience. If somebody is a specialised plastic surgeon, or if they have the less qualified title of cosmetic surgeon. Thank you for coming today, and I hope you have learnt more about the factors that go into negligence in these medical liability cases. And please feel free to come up and have a chat with me after if you have any interest in pursuing your claim.
I'm gonna sue him!